morning, everyone. Welcome to our 30-minute construction risk series, during which we will be having a discussion about hot employment topics. My name is Michelle de Oliveira. I'm one of the employment attorneys here in the office.
And my name's Laura Raisty. I'm another employment attorney at the firm. And we are going to start the webinar today by talking about an overview of the status of the Biden administration vaccine mandates. The first vaccine mandate that came down was the one for federal contractors. That has been suspended nationwide as of December 7th, 2021, when a federal court in Georgia put a stay on it, essentially, and said that no part of the federal contractor vaccine mandate could proceed. An appeal by the government is expected in this, and we will likely see it at the end of the day, probably go up to the Supreme Court as well. So what I would advise right now for federal contractors is keep an eye on your contracts. Given the stay, the government might stop including the clause that requires compliance with the COVID guidance that came out from the Safer Federal Workforce Task Force. So, look at your contracts, see if it's in there. And presently, if it's in a contract that you've entered into since it came into place, you need no longer comply until this issue gets fully resolved in the courts. In the meantime, you might want to consider collecting proof of vaccination regardless, CDC record or other medical record. Again, federal contractors cannot use a certification or an attestation as proof of vaccination status. If you are collecting that data now, you'll be ahead of the game if the state is listed, particularly if there's a short timeline for compliance if that happens. Next, I'm going to turn to the OSHA Emergency Temporary Standard, or what everyone's calling the OSHA ETS. That was the vaccine mandate that applied to employers who have 100 or more employees. That too is currently suspended as a result of a number of lawsuits across the country. Appeals of that were challenged in every circuit court in the country. There was a lottery to decide which circuit court would hear the issue, and the Sixth Circuit, which is Michigan and Ohio in that area of the country, won, if you can call it a win. The case was fully briefed as of last Friday, December 10th. I'm going to paint in very broad strokes the arguments that were made in that case. The first is that the ETS is arbitrary. Why did they pick the threshold of 100 people? Why not 75? Why not 125? So that's one argument that's made. Another argument that is made is that OSHA lacks the authority to issue the rule requiring mandates for private employers because it wasn't granted that authority by Congress. So it's a legislative act when it doesn't have the power to legislate. Another argument is that the ETS is too broad. It doesn't just apply to workplaces, it applies to everywhere, because you're not just vaccinated when you're at work, you're vaccinated wherever you go, obviously. And lastly, is COVID still a grave danger warranting such measures, given that we're now 2 years into the pandemic, and the ETS has an out essentially with the testing requirement? And, as of, presently, more than 70% of the country has received at least one dose of the vaccine. Given the variants, I don't know how strong that argument is going to hold up as the coronavirus mutates. I think that each time each variant presents a different danger. So that is my opinion, but I don't know how strong that argument is. The Sixth Circuit, which is deciding this issue, is known to lean conservative, with most of its judges appointed by Republican presidents. 6 were appointed by President Trump, 5 were appointed by President George W. Bush, and a total of 5 were appointed by Democratic presidents Bill Clinton and Barack Obama. Now, vaccines can be viewed as or are being viewed as a political issue in this country, with most people thinking, well, Republicans will do away with any vaccinations day, and Democratic courts or judges would be more likely to uphold it. I think that's reading tea leaves. I don't think that the issue is that simple when you get to the courts, and I think making that assumption is going to be a mistake. I'll also point out that in large part, vaccine mandates have been upheld by Republican judges. I think with the exception of these two federal government vaccine mandates that courts have upheld them. So I don't know that you can necessarily ascribe what's going to be happening here to the fact that there's more Republican judges on that panel than not. I also think this case is pretty much guaranteed to go to the Supreme Court. So just keep an eye on this, on what's happening in the Sixth Circuit. If they do lift the injunction or lift the stay, the ETS requirements could become effective immediately, or they could become effective on a later date set by the Sixth Circuit. So you just want to keep an eye on that, and be prepared to comply with the mandate, or if it does become active again. And later on in the program, we're going to talk about some best practices going forward to make sure that you're ready if that happens. And with that, I am going to turn it over to Michelle, who's going to talk about a very interesting case on vaccines that just came out of the First Circuit Court of Appeals here in Massachusetts.
Thanks so much, Laura. So, unlike the way in which courts have blocked President Biden's executive orders with respect to vaccination mandates, employees in Massachusetts have thus far been unable to persuade a court to stop enforcement of a mandated COVID-19 vaccination policy that the Mass General Hospital instituted. I will start off by saying that this case is unique in the sense that it is dealing with a hospital, and we're dealing with employees who are in a healthcare setting. And it's unclear at this point whether outside of the healthcare setting, a court would take a similar approach. But in any event, employees have pushed and have raised a series of very interesting and persuasive arguments in that case, trying to get the court to stop Mass General from being able to enforce the policy. And like I mentioned earlier, they have not been able to succeed thus far. In that case, I will also note that the courts are carefully scrutinizing and reviewing reasonable accommodation requests and the bases for the requests. There is very helpful language in that decision that we believe employers who wish to implement their own COVID-19 vaccination policies may be able to utilize moving forward in the event that a private employer is faced with a lawsuit and finds itself in the middle of a litigation. And I'm just going to talk about briefly some pieces of helpful language in that case, because I do think it's helpful for us to get a sense of how are courts looking at the issue, how are courts looking at potential impact of COVID-19 in the workplace, and how are courts looking at the reasonable accommodation issue. I do think that this case is a window into what a private employer would see a court saying, or at least looking at, in the event of litigation. So, for example, in the case, the court says, stopping Mass General from enforcing the policy intended to curb the spread of COVID-19 is not in the public interest. The virus has infected and taken the lives of thousands of residents, and dismantling the policy would undermine the defendants or the hospital's effort to combat the pandemic. The court talks about how the virus is transmitted, how long infected persons are contagious, and the potential risk that unvaccinated employees have to other employees, visitors, and staff. And the court says that all of those things are relevant factors when looking at and assessing whether an employer may go ahead and implement a mandated COVID-19 vaccination policy. The court goes even further, and it says that it's undisputed that COVID-19 and particularly the variant, the Delta variant, is a highly contagious disease. It's transmitted in large part when people are close to each other. It's undisputed that the virus is serious and is fatal. Under those circumstances, the court determined that the hospital had the right to implement the policy, and the employees were just not able to prevail, because what the court also looked at, and we're going to be talking about a little bit later on, the notion of a direct threat, that COVID-19, as we know, has been deemed a direct threat in the workplace. And for those reasons, the court found that the hospital had the right to implement the policy, and while assessing the direct threat that unvaccinated employees presented in the workplace. Interestingly enough, we've spoken before about testing in lieu of vaccination, and whether an employee who decides to not get vaccinated could just submit to weekly testings. That was part of OSHA's ETS as an alternative for mandatory vaccination. In this case, what the court said is that testing in lieu of vaccination provides a false sense of security. So in other words, there have been cases in which people get a negative test, but then find out that they were actually positive, or because of when a test is actually able to diagnose the virus, those things are all fluid. And so for that reason, the court said that testing in lieu of vaccination provides a false sense of security, once again siding with the employer in supporting its decision to implement the policy. Moreover, the court stated that social distancing, depending on the nature of the work that somebody is doing, is not always possible. And in this case, the employees had stated that, as an accommodation, what they could do is be socially distant from others, and that there were other, steps that the employer could take to ensure, that the safety of everyone within the hospital. And what the court said is no, it's not something that's always practical. And so, again, it's unclear at this point whether a court would scrutinize a mandatory COVID-19 vaccination policy in the private sector the same way as it did in this case. But we wanted to share it because I do think it is a window into the way in which courts are looking at this and allowing employers to implement these policies. And unlike the federal government, and we've seen the way in which the courts have blocked the federal government's attempts to implement these mandated policies and these requirements on employers, it's different when we're talking about a private employer who is taking steps that it deems reasonable for its workplace. With that said, I want to move on to another topic. We've been getting a lot of questions lately from clients about, what to do when somebody tests positive, or what to do when somebody needs time out of work to be vaccinated, or what to do when somebody has been exposed to COVID. We've been getting a lot of those questions, and we just want to remind everyone that in Massachusetts, we actually have a statute, that's the Emergency COVID-19 Paid Sick Leave Law, that provides paid sick time for employees who have COVID, who have been exposed to COVID, who may be seeking treatment for COVID, or who may otherwise be subject to an order to quarantine or to isolate themselves from others. On top of that, the sick leave law provides paid leave for somebody who needs to go get vaccinated, and then to the extent that person suffers any symptoms or doesn't feel well post-vaccination, the law also provides for paid time out of work for those reasons. In addition to that, the statute will provide paid leave for an employee who needs to care for a family member who is either getting vaccinated and needs to recover, has COVID, or is seeking a medical diagnosis, or is subject to a quarantine. So in other words, pretty much the same reasons that an employee can be out of work because of a COVID-19 related reason that is impacting the employee himself or herself, The statute also provides paid leave to employees who need to be out of work to care for a family member for a COVID-19 related reason. This statute has been extended until April of 2022, and employers who provide paid leave to employees under this statute will be entitled to a reimbursement from the state through a fund that has been established for precisely this reason, to provide paid leave to employees who need it for the reasons under the statute. Notably, the maximum leave that an employer can get reimbursement for is $850 per week. So if you have an employee who makes more than that, employers should just note that the state is not going to reimburse you for anything over $850 per week. Another thing to keep in mind is that the amount of time that an employee may be entitled to will vary depending on the amount of time that the employee works. In other words, if you have an employee who continuously works 40 hours per week, then that employee would be eligible for the 40 hours of paid time off under this statute for these reasons. If, however, you have somebody who works less than 40 hours regularly, then that employee would not be entitled to 40 hours of paid time off for the week. That employee would be entitled to whatever amount of hours the employee is regularly scheduled to work each week. If you have an employee who works on a schedule that varies, the way in which you calculate how much time the employee will be paid will depend on whether the employee has been working with you for 6 months or not. So because of these varying calculations, we'll just say if there's an issue that comes up where you have an employee who's not on a fixed schedule and is working less than 40 hours a week, and if you have questions about how much paid time off the employee would be eligible for, just contact council, reach out to us, and we're happy to help and provide guidance. Notably, it's if somebody has already used the time, they don't get an additional 40 hours. So this is not every time you get COVID or every time you get exposed to COVID, you get 40 hours. This is a 40-hour leave benefit that's available for the benefit year. So once the employee uses it up, it's gone. It's not available anymore. It doesn't mean you're going to let somebody, force somebody to come into work when they have COVID. It just means they're going to be out. And unless they have PTO for use, unless they have earned sick time available for use, then they would be out unpaid. Which brings me to another really important point. The benefits and the time off allotted under this statute is in addition to and on top of the Massachusetts earned paid sick leave. So theoretically speaking, if you actually have somebody who has 40 hours of sick time for use, that those 40 hours of sick time for use would stay untouched, and the employee could use the 40 hours under this emergency COVID-19 paid sick leave law, and then be able to use the 40 hours of sick time at a later point. There is a sample form that employers may use, and I actually encourage employers to use, that the department has published. And it is a form that if you give it to your employee to fill out when they need to go out on leave, the employer will then be able to use the same form and the same information when applying for a reimbursement through the state. And the application for reimbursement is done through Mass Tax Connect. With that, I will take it over to Laura.
Thanks, Michelle. The next topic we're going to cover is the Massachusetts Attorney General's updated frequently asked questions about COVID-19 employee rights and employer obligations. That was issued on December 10th. It's fairly easy to find on the internet or on the Attorney General's website, and it's written in, not in legalese. It's written to be generally understood. So I do recommend that folks have a look at that. I will point out, however, that its language is very couched. It's qualified in a lot of ways, and you'll see how that is the case when I talk about a couple of the points in there. So the first point is one of the big topics covered is what's considered compensable time you have to pay your employee for when they're going to get a vaccine, when they're going to get tested. And the Attorney General has come down for vaccine that the time spent getting it is likely not compensable, so long as the employer does not mandate when, where, and how the employee gets the vaccine. However, if the employer does say, you employee need to report to location A and get the vaccine on Monday at 3 o'clock, that is probably compensable time. It's the same with regard to travel. If the employer simply requires proof of vaccination, they do not have to pay for your travel time to go get it, again, so long as they're not dictating, when, where, and how you're getting that vaccine. Another issue that's in there is also masking. Who pays for masks? Generally, and again, the language is very qualified here. The employee will have to pay for the mask unless it's a specific mask that you're being required to wear. For instance, one with the logo of the company. The employer will likely have to pay for that. If there's a specific type of mask that's required, like with a respirator, the employer may have to pay for that. You want to also be careful in situations where you're requiring an employee to wear a mask that has a logo on it, that you're getting now into having a uniform, which employers are responsible for uniforms. Turning to testing in lieu of vaccination, when do employers have to pay for the time associated with that? Again, the time is likely not compensable if all the employer requires is a test result and does not mandate when, where, and how it's obtained. If you do mandate when, or if you do direct when, where, and how it's obtained, you've probably now made that into compensable time. One situation that's not clearly addressed or not addressed in the frequently asked questions is, what about reasonable accommodation? What about if somebody has to get tested because it's a reasonable accommodation for a religious religious concern or a disability? What if somebody has to wear a specific mask because of a reasonable accommodation issue? I think Michelle and I are in agreement in this, that we think that in those situations that the employer is likely going to have to pay for that. Because in this situation, there's really no alternative to keep the employee working. And having testing done for that one employee, we think will probably be viewed as a de minimis cost in providing an accommodation, and that employer would likely have to bear the cost in that situation. Again, if you have any questions about that, Michelle and I are certainly available to answer any questions that you might have. But again, I would recommend have a look at the Attorney General's guidelines. Again, clearly written, not very long, and it's aimed at answering some of these basic questions about what's compensable and what's compensable time. It also addresses things that we've covered in previous webinars. Can you require your employees get vaccinated? Who pays for the vaccine, things like that. The known answers to which are, if you're interested, yes, you can require your employees to have a vaccine. And second of all, right now in the state of Massachusetts, vaccines are free. So nobody is bearing the cost, I think, other than the federal government for that at the moment.
One thing that I just wanted to add, I think it's important to note that the notion of whether it's compensable time or not, as Laura had mentioned, the AG's office is saying likely not compensable, and the information we have from the AG's office is merely guidance. When we're looking at the question about whether something is compensable time or not, the Federal Labor Standards Act also comes into play, and that is federal law. And thus far, the Department of Labor has not spoken on this issue, and we don't have guidance on it. So what I'll say is this: right now we have the guidance from the AG's office, but it's really an area of law that's unsettled. We don't have clear guidance about whether it should be comp time or not comp time, other than knowing that if you're requiring an employee to get vaccinated or get tested, during work hours or at a specific time, then we can say comfortably that that would be comp time. If that's not the case, then I do think this is an area that if we don't get additional clarification and specific guidance on it, it is an area that we anticipate seeing litigation over, because we do know that the plaintiff's bar is taking the position, or I shouldn't say the plaintiff's bar as a whole, some plaintiffs' attorneys are taking the position that if you're requiring testing or if you're requiring vaccination, it doesn't matter when the employee is getting it, it should be comp time. So I just wanted to throw that in there because it's important to keep in mind that the information from the AG's office is merely guidance, and it isn't settled law on the issue.
Yeah, that's a very good point, Michelle. That's the reason why they're using that qualified and couched language of likely and unlikely. It's because we don't have guidance from the federal government about how they're going to interpret the Fair Labor Standards Act with regard to these issues. Now I want to return to best practices. Number one, continue to follow the CDC guidance on masking and social distancing. This means for unvaccinated workers, wear a face covering and stay at least 6 feet away from other workers. For your vaccinated workers, they are essentially free of masking and social distancing if you so desire. However, the CDC does recommend that they wear a face covering indoors in public if they are in an area of substantial or high community transmission. And again, I believe right now most of the country is still considered to be in an area of substantial or high community transmission. Second, have a plan for exposed, symptomatic, and diagnosed employees. And again, here we recommend that you follow the CDC guidance. For those who have been exposed, unvaccinated workers should quarantine if they have been in close contact with someone who has COVID-19. Close contact is considered within 6 feet of someone with it for a cumulative total of 15 minutes or more over a 24-hour period. Vaccinated workers need not quarantine after exposure unless they have symptoms. However, fully vaccinated workers should get tested 5 to 7 days after the exposure, even if they don't have symptoms, and wear a mask indoors and in public for 14 days following the exposure or until they get that negative test result. Symptomatic, it's the same for your vaccinated and your unvaccinated workers. They should self-isolate. That means stay home from work. They should be clinically evaluated for COVID-19 and tested if the clinical evaluation deems it warranted. It's likely going to be warranted for your unvaccinated workers. It's up to the medical professionals in terms of vaccinated workers. For folks that are diagnosed with COVID-19, again, unvaccinated and vaccinated workers, it's the same. Self-isolate for 10 days. Follow medical advice as to whether they need to be tested before they can resume being around other people, and that includes returning to work. Now I'm going to hand it to Michelle to cover some additional best practices.
Thanks so much, Laura. I just want to say that, at this point, we know employers may implement mandated COVID-19 vaccination policies if they decide to. You don't have to, but if you decide to, you can. One of the best practices that I couldn't emphasize it enough, regardless of what you as an employer decide to do, whether it be implement a policy or not implement a policy, have a policy implemented within the workplace that will establish the safety protocols and procedures that you want your employees to follow, and then enforce it. Adhere to the policy. And I think once employers start doing that, it's going to create less tension among employees, which is also something that we have been seeing, because this is an issue where people have very different thoughts and ideas relating to COVID-19. And if you have a policy in the workplace, and if an employer is enforcing it consistently, it is a way to reduce tension among employees who have concerns relating to COVID-19. So if you have a mandatory vaccination policy, have it in writing, not just verbal, have it in writing, have it be a thorough policy, and then be sure you're following it. And if you don't have a policy in place that deals with safety protocols and procedures, and be sure that your employees are being held accountable to those standards. Information regarding an employee's vaccination status is considered private, confidential medical information. And that is regardless of whether the person is vaccinated or unvaccinated. And I think that may sound bizarre to some, that the fact that somebody is unvaccinated is considered private medical information, but it is. And so if there are issues where employees have questions about their coworkers' vaccination status, just remember you as an employer shouldn't be disclosing it. If you have questions from clients, you shouldn't be disclosing it. There are ways to going around and addressing the issue of conveying information to a client who is requesting information about vaccination status. And as a best practice, that would be ensuring that you get permission, signed authorization from your employee to disclose information to clients if necessary. And we're seeing that a lot of our clients are having clients themselves in the construction industry who are demanding that employees going to a job site be fully vaccinated. So just be sure you have a policy in place whereby you're disclosing that to your employees, making them aware of that as a potential requirement, and then to the extent you need to disclose it, that you have written permission from your employee. We're running out of time. I just want to say one more thing. Train your managers on reasonable accommodations, because this is an issue that we've been getting a lot of questions about. It's a thorny issue that has been litigated a ton, and it's an issue that is not black and white. If it were an issue that was black and white, I'm sure Laura and I would be getting a lot less questions on this issue. It's something that is very complicated and convoluted, and only because it's very fact specific, and there is no bright line rule. And so what I'll say is, as a best practice, be sure that you as an employer, you're educating your managers and your workforce about how to handle anything relating to accommodations, restrictions, changes to job, exceptions to policies, etc. Because I think that can really go a long way for you as an employer. And with that, I think Laura will have a few additional words to add.
Yes, thank you. And we do realize we're running over, but we wanted to make sure that we get everyone sort of a full picture of information. So lastly, I want to talk about what employers with 100 or more employees might want to consider doing now, so long as you're not a federal contractor or a healthcare provider, because those are covered by different provisions. But if you're a private employer that's not a federal contractor, not in a healthcare setting, what should you consider doing now in light of the fact that the ETS has been blocked? Consider doing the following to prepare in case it does come back to life and applies to your workplace. Number one, decide in the event that the stay is lifted, will you have a mandatory vaccine policy or allow your employees to choose between being vaccinated or having regular testing and wearing a face covering? Different factors affect that decision. Michelle and I are happy to talk those through with you. Next, be prepared to handle requests for medical and religious accommodations for exemptions to a mandatory vaccine requirement or another aspect of a COVID-19 safety prevention. If the stay is lifted, you're going to need to determine the vaccination status of your employees. Consider if you want to get a head start on collecting proof of vaccination now, keeping in mind what Michelle just said about confidentiality of medical records. Think about developing your roster. The ETS requires a roster that shows who is fully vaccinated, who is partially vaccinated, who has a religious or medical exemption, and who is unvaccinated, either because they just are unvaccinated or because they have not provided you with proof of vaccination. And lastly, if you are going to use testing, who's going to pay for it? Will you outsource it? Note that the Attorney General's frequently asked questions that I just spoke about said that if the employer does not mandate the testing, it is unlikely that the employer is going to have to bear the cost of that test. Again, we point out the word unlikely, because that is certainly not binding. I know we flew through those pretty quickly. I apologize. We thank you for your time. If you have any questions, again, please feel free to contact either Michelle or I. And we lastly invite you to the next webinar in the construction law risk series, which will be next month on the third Thursday of the month. Thank you very much for joining us this morning and for indulging us in going 5 minutes over. And we hope everyone has a good day.